So today, Rupp versus Becerra, a very similar case to Miller versus Becerra, was heard at the Ninth Circuit Court of Appeals in front of a 3-judge panel. Now, I'm going to leave a link down in the description to the entire hearing today. You're going to want to skip towards the end to when they actually begin the Rupp versus Becerra discussion. I wanted to put together just some little highlight clips that I thought were specifically notable that I think you're definitely going to want to see. When I heard them and when it was shown to me, they made me kind of either drop my jaw or nod along positively because I thought they were either so good or so bad. So I wanted to kind of give you these clips that were sent to me and share it with you guys. This was a case that, while is very similar to Miller versus Becerra, I don't think is going to necessarily be as fast or as cool of an outcome. We're not going to really have some sort of freedom week because by the time we actually hear a decision on this, it's most likely going to send it back to the lower courts. It's not the same sort of way with Benitez being able to just say, hey, yeah, assault weapons are really cool and you should have them now. It's not going to be like that. We're most likely not going to hear a decision for many, many, many months. But this is good because it was something that challenged a lot of different things. I'll talk about that more in just a second and then we'll roll the clips. But I really wanted to say thank you to the sponsor of this channel, Franklin Armory. They've been a huge supporter of me. They've been a huge supporter of California with their CA7, CA11, and CA12. They've also been a huge supporter nationwide with their various products that are meant to bend and work around the NFA laws, which we know right now, braces are kind of under attack. So who knows what we're going to be able to do. I'm going to be looking towards Franklin Armory for guiding us into the future as far as maybe what happens. And I'm very appreciative of having their support. Go check them out. Go show them some love for the company that go above and beyond us in California. So Miller versus Becerra is very similar, and that's going to be a different topic for a different date. But Rupp versus Becerra, the main points that were talked about today, they discussed the concept of intermediate scrutiny versus strict scrutiny. Strict scrutiny basically says, it's a lot more difficult to pass a law that infringes upon your rights, which we all know, go ahead and type it down in the comments right now, shall not be infringed. But that's not necessarily how the courts work, unfortunately. The state really wants to apply intermediate scrutiny, which would mean that even if it does infringe upon your rights, if it's narrowly tailored and if there are alternatives, and it basically gives them a lot more leeway, it allows them to infringe on those rights as long as there's some sort of alternatives or that it's narrowly tailored for the specific goal that the state is looking to accomplish. Their goal of accomplishing what they say is that they want mass shootings and attacks on law enforcement to be mitigated or reduced completely. What we know is that they don't want us to have guns that would be adequate for self-defense, and one of the clips that we're going to roll in later is going to specifically talk about how inadequate these assault weapons are for self-defense, and it's going to probably make you scream. But enough of me yammering on. Bottom line, what you need to know. This case is not going to be as fast. It's not going to most likely give us any sort of freedom week, as we've all colloquially determined to call these cases that give us some sort of freedoms back. Yes, I know, at the stroke of a pen over one day, we could have our freedom stripped away, but it's going to take years and years and years to get them back. And I know that's wrong. Obviously, we all know that's wrong. That's not how it should be. But the courts are going to do it anyways. Whether you choose to follow the law, I'm not going to stop you. Nothing that I say on this channel is legal advice because I'm not a lawyer. Let's roll the clips.
But I think doing it feature by feature would be actually more beneficial and helpful to appellants because it would show, at the risk of losing decorum, it would show the absurdity of why these features are restricted. I mean, we're talking about an adjustable stock. If your stock moves an inch or two on your rifle, then you're a felon. If it doesn't, then you're fine. But assuming that intermediate scrutiny should be the appropriate test, I think they were wrong because if something is constitutionally protected, if it can be banned, then what good is the constitutional protection? It's essentially meaningless. If these arms are indeed protected, then there has to be, protection has to mean something. And that something is that they cannot be wholly banned. They can be regulated, and they already are significantly regulated. What we have here is not a regulation; it is a ban.
Can I ask one other threshold question? It looks like commonality. You're suggesting commonality. How common the weapon is part of the test of whether or not it's protected by the Second Amendment. Where does that come from, and how is that not a circular argument? If a state bans something, how it's not going to be common, I assume.
It is something that courts will have to wrestle with. But I don't think that this court has to with this particular issue, because these rifles are, as the Duncan court explained, the most popular rifles in American history.
California's restrictions on assault rifles, as defined by the Assault Weapons Control Act, is constitutional. And it's notable to clarify at the outset that California does not restrict all semi-automatic rifles. Rather, the regulations at issue here restrict only a specific configuration of semi-automatic rifles that the record shows to be particularly lethal, of being used disproportionately in public mass shootings and against law enforcement officers.
Counsel, do you agree with Mr. Rupp's statement, Rupp's counsel's statement that the firearms here include the most popular weapons in history?
I don't, Your Honor. There's simply no evidence to show that. Correct. The only difference between an M16 rifle and an assault rifle is that the M16 rifle is a select fire. That means in addition to firing in semi-automatic mode, you may also fire in automatic mode. So
do we do that for any other right, where we look at a fundamental right and say, well, we could restrict one right because you have alternative rights? Do we do that in the First Amendment?
I believe so, Your Honor. I mean, the First Amendment definitely restricts certain types of speech in certain types of situations, or permit those restrictions. For example, it's constitutional to restrict, yelling fire in a crowded theater.
I mean, I think most courts would say that that's just not protected by the First Amendment. But whereas if we can see that an arm is protected by the First Amendment, or a right is protected by the First Amendment, where do we say that it's okay to restrict it as long as you have alternatives? Can I ask two quick questions? Do California police officers have access to these banned weapons?
They do. Law enforcement officers do have access to what the AWCA categorizes as assault rifles. However, there's testimony in the record that says, unlike civilian use, law enforcement are more prone place themselves in offensive situations, which is not a self-defense situation.
Well, doesn't that undermine your argument that these are only military use weapons? If civilian police use it, then it's not only military use? Can I ask a follow-up on that? And what makes it particularly dangerous? Isn't it because it's more accurate?
It's more accurate when it is fired in a rapid rate. On a single shot basis.
Does the government have an interest in having less accurate guns out in the public?
No, well, in the public setting, yes. I mean, in a public mass shooting situation, we don't want the shooter to possess a rifle that can be fired very rapidly, very accurately.
What about in the self-defense setting?
In a self-defense setting, those features are simply not necessary. And we have...
But they make it more accurate. Wouldn't you want more accurate weapons in a self-defense setting?
In a self-defense setting, there's no need for rapid fire. In the average self-defense situation, an average of 2.3 rounds are fired. There's no need to fire off 10, 20, or 30 rounds in a very rapid succession.